Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. And in a move stirring intense debate across India, the Gujarat government has proposed amendments to the Gujarat Registration of Marriages Act, mandating parental notification for all marriage registrations the parents must know. Under the draft rules which have been announced, couples must declare whether parents are aware of the union, and authorities will notify both sets of parents, often via WhatsApp, within 10 working days of the submission of an application. Now, the changes aim to curb elopements, they aim to prevent alleged fraud and address concerns over love jihad, with supporters arguing that it promotes transparency and family involvement. But let me ask you this, isn't this proposal a direct assault on adult autonomy? What about the landmark Hadia case, where the Supreme Court upheld that consenting adults have an inviolable right under Article 21 to choose their partner and faith without state or a veto from their parents? Legal experts warn that it risks enabling coercion, violating privacy, and discriminating against interfaith or intercaste couples, potentially facing swift constitutional challenge. Well, joining us now to look at this, Mihira Sood, Brinda Adige, Satya Mule, and Ashwani Dubey. I'd like to thank you all very much for being with us. Now, Mr. Mule, as I understand it, in a key judgment in April 2018, the Supreme Court ruled that courts have no jurisdiction to annul a valid marriage between two consenting adults under writ jurisdiction, Article 226, especially when the woman testifies to her free choice. Why in 2026 is any state government planning to do this?
Well, what has happened is that there have been rising cases of frauds in marriage, specifically multiplicity in marriages, that is bigamy. Apart from this, there have been issues wherein fake identities have been used. Also, there have been a rising major issue, that is of love jihad, that has been rising in our country. And there has been several communities, they themselves have been requesting this particular rule. However, this rule, the way it is looking at, we cannot say that it is a refined version of the rule and cannot be debated threadbare, because there are a lot of possibilities in this particular situation wherein the privacy of the couple will be at stake. However, we have to compare that this particular requirement is not fully not justified. It is a requirement per se as per the changing scenario of the various situations of demography. Now, we have to see that in context of Maharashtra, Special Marriage Act also has a rule which states that there will be a notice of 30 days to be given to public at large. Now, this public at large includes the parents, and it is open for public at large.
Mr. Mule, I think the larger question, sir, in 2026, if two consenting adults choose to get into a marriage, who are we to stop them? Are we that illiberal a society that adults cannot make their own choice? Firstly, sir, and secondly, sir, as I'm sure you know, there is no centralized data or NCRB statistic to support the belief of widespread love jihad.
Yes, that's perfectly fine. I don't think the government has got any concern, or the government doesn't want the consent of parents as such. And in fact, the government doesn't even want to go towards annulment of marriages, because the case of Hadia in Supreme Court, it has already been clarified. So what the government wants to do, that everybody should be informed about a particular event that is happening under a particular law.
Why, sir?
This is the only thing. It may cross the line and it may start appearing as.
So what is the line? Consent. But anyway, Mihira, two key points, Mr. Mule. Mr. Mule feels that there is a line which may be breached and all parties need to be informed. How would you respond, Mihira?
First of all, I want to say that even assuming that there are cases of fraud that Mr. Mule alluded to, there is no...
Mr. Mule, 1 second, let Mihira answer. Yeah, go ahead, Mihira.
There is no correlation between informing parents and curbing that fraud. Secondly, if at all somebody enters into a fraudulent marriage, there is a criminal law to deal with that situation. It does not require parents to get involved. Thirdly, there is no such thing as love jihad. There is something called interfaith marriages. Okay? If Mr. Mule or the government or anybody else has a problem with love jihad, what they are really saying is they have a problem with interfaith marriages. If an interfaith marriage is being conducted on the basis of fraud or deception or anything like that, it does not require this step. There are already remedies for that in criminal law and tortious remedies.
Mr. Ashwini Dubey, the right to choose one's religion and life partner is a key part of personal liberty, right, under Article 21. Therefore, interference by family, society or the state is legally, as I understand it, not permitted. It's impermissible unless there is clear evidence of coercion or incapacity. Why should we get into this in 2026? As Mihira pointed out, if there is coercion, there are already pre-existing laws. No one can be coerced into anything. Why have another set of laws now?
Vishnu, you are asking this question from me?
Yes, sir.
Oh, Vishnu. First, let me clarify. At the cost of repetition, after Hadia judgment came, we had discussed this issue. Again, I am discussing.
It's come back in the news, sir. What goes around comes around.
Yes, Hadia case was an issue where parents had said that she was brainwashed and she had got married to a person by brainwashing and there was coercion. But the court, Hadia, stood firm with the marriage and said no, there was no coercion.
Correct.
And I had willingly married. The Supreme Court said in root jurisdiction, Vishnu, let me complete. In root jurisdiction, Supreme Court said a valid marriage we cannot annul. But so far as the state's power to legislate a law, that too under Article 246 and 7th schedule, and matters in list 2, state list, and list 3, concurrent list, are different from the judgment which we have just discussed. This is at the cost of repetition. Now 2. The Gujarat law, Vishnu, with respect to you, with respectfully says 30 days waiting period to prevent fraudulent marriage so that the parent should be informed. In Special Marriage Act and Marriage Registration Act, there is already a provision where the notices go to the parent. Parents may come or may not come. Here it has been made mandatory that 30 days cooling period is there. Number 3, if two consented adults wants to get married, why to hide from parents if somebody is going to get married to a person of his or her choice?
Because they may not want their parents to know.
Just Vishnu. If the marriage officer rejects on this basis, the court under Article 226 and Supreme Court under Article 32 has a right to protect those couples. Now another question. If a law is violated to the fundamental rights of Article 21, Vishnu, with great respect to you, it is open for the aggrieved person to approach to the High Court or the Supreme Court.
But why would somebody? So that sir always exists. We are asking for, if you look at 2018, Shafin Chahan versus Ashokan came, the Hadia judgment, the Supreme Court upheld adult autonomy. They stated that courts cannot annul consensual unions or intrude into personal choices. Despite this, what you're saying is that legislating laws allows this to take place. But doesn't that breach? No, you said that in the case of Maharashtra and elsewhere now in Gujarat, you have the right, the state governments have the right to try and legislate. That is what you have said. The question is a larger point, sir. Why would one want to legislate in the face of a very clear judgment? It is to try and curb interfaith marriage.
No, this is in order to prevent fraud and coercion.
Sir,
parental notification.
Nobody on this planet and in our system can prevent or coerce you or me. We have 50 remedies.
That's what. Now another, so far as the judgments which you have referred, does that judgment says that the state cannot...
No, it doesn't say so. But I am arguing that it defeats the purpose of a judgment when despite that clear judgment I read out, a state tries to do this.
It is an attack on the adult autonomy.
Brinda, come in. Brinda, otherwise you will be left without any say in this conversation. Please go ahead, Brinda. Yes.
First and foremost, let us place on record very, very clearly that the proposed bill act that Gujarat is bringing is unconstitutional. Because like you pointed out, it is not only a violation of our constitutional guarantees, but it is also telling or disregarding the already available laws, sections and legal provisions that are there for anyone to go and complain. Now, what is it that the law is trying to say is, here in Mother of Democracies, in a land where Gandharva bonds was celebrated, now no longer will any adult, as per the constitution, have an agency to make a decision who their life partner or their partner should be. We don't want to talk about a life partner just now, but even if it is a partner. Now, who is the state to dictate my private choices? Parents, our panelist also pointed out, it is mandatorily information to the parents. And the parents must and should come to the DC's office over there when the marriage is happening. Now, you know that 99.9 cases in such marriages, it is always a dialogue that you and I have heard for the last 120, 50 years since movies came into being. Over my dead body. Which child wants their parents to get to die just because they have to get married? And because of that, they go away. Because in a family, once marriage is done, marriage is over, we come back, there's a lot of forgiveness. There's a lot of acceptance. So you are now nullifying all of that and creating this big enemy division between the family members, bringing a law like this saying, I want to uphold purity of caste and religion. At the end of the day, that is the stuff that you are bringing in between. You may not say it in law because it is not allowed. But otherwise, that is the information you're going around and telling. I brought in a law, your parents will now come if you want to get married. And if you really want them to die and get married, why are you interfering?
Okay, I take your point. Ashwini Dubey, by informing parents when a couple wants to get married, isn't this law attempting to conduct a roving inquiry into the motives behind a consensual marriage? Is that at all possible?
No, that law.
How do you assume that the parents and what they say is correct, and how do you deny the rights of adults in a relationship? The government, right, the authority would conduct a roving inquiry? How?
This is just in order to strengthening the role of registrar and ensure the transparency and scrutiny. Even on the given date, if parent comes and say, I don't agree to marriage, registrar may proceed with the marriage. This is the law of the land, settled law. Special Marriages Act and the Marriage Registration Act says so. It is not that it is open for the parents to say this marriage can't happen. That marriage between the two adults will definitely happen, be it the state of Gujarat and any other state. This is not attack on the adult autonomy. This is only ensure parental awareness. Why do you don't want to make your parents aware about the marriage? This is to prevent fraudulent marriages. This is to procedural accountability. That is why required.
Okay, Meera, it's a safety measure. Ashwini ji says, how would you respond?
1 second. I think we have to go back to some basic fundamentals in law here. When somebody has a right to do something, it is not for other people to question, why do you want to do that? Why do you want to exercise that right? That is imposing your own morality. When somebody asks, why should you want to hide it from your parents? That is frankly nobody else's business. I have a right to get married. I have a right to get married without informing my parents. I don't need to explain to anybody why I wish to exercise that right. All right, that is, we need to understand that very basic thing, that we do not need to justify our exercise of our rights, right? The state has to justify its intrusion into our rights. We do not have to give a good reason for it. It's my right. I don't need to give a reason. It's as simple as that. And you know, this entire thing of parental awareness and why should you want to, it makes a lot of assumptions. Everybody does not have the same kind of relationship with their parents. Everybody does not have a similar sort of familial setup. More importantly, why are we infantilizing adults? Adults have a right, and this is another aspect, a basic fundamental aspect. Adults have the right to make mistakes also. Parents may think, oh, this is a bad idea, this is a mistake, I have your best interest at heart, you should not be marrying this person. Maybe they're actually right, maybe, but they still don't have a right to interfere. Children Grown up adult children have a right to marry who they want, even if it's a bad idea. They have the right to make mistakes. They have the right to be brainwashed in love or whatever else anybody is saying. These are all well within their rights. And the government needs to recognize that and recognize that we cannot control every aspect of an adult human being's behavior, even if we disagree with it.
You know, Mr. Muley,
One
the
more
other point
I'd like to share.
Just half a
It's
second.
also
Half a second. I just want to
agency.
keep the strike rule. Go ahead, Mr. Muley, make your point. Yes.
What happens is, it is not a matter of curtailing any liberty of any adult. If there is any legislation in place which in fact is touching upon any fundamental right, we have to understand that none of the fundamental rights are absolute. For that matter, if you want to travel, you have to declare at the airport where you are traveling, for what purpose you are traveling, so on and so forth. As long as the objective of this particular legislation that is proposed to be brought into place is trying to prevent fraud, is trying to bring in transparency, is trying to bring in protection for some kind of vulnerable sections of adults, then this particular legislation can be welcome, considering the changing demographic issues of particular border states, or for that matter any sensitive states. Now this legislation, whether it can stand in the court of law or not, there are 5 parameters. Number 1, whether there is a need for such a legislation, that has to be answered. Whether it has a valid purpose, that has to be answered. Whether it is excessive, that has to be answered, and whether it is reasonable, that has to be answered. These are the touchstones that the Supreme Court will evaluate at the time of trying this particular legislation, whether it is constitutionally allowed or not. Now, considering various scenarios since last decade or last 2 decades, we have seen that freedom, Article 21 has seen the maximum stretch in this particular country, and again in 2026, it is the very own Supreme Court is trying to say that teenagers, there should be some kind of restrictions on freedom of speech, or for that matter access to social media. Same
But
Supreme
sir,
Court
that
is
doesn't
trying to
have
say-
it. That is not linked to this, sir.
That is not
linked
but
to
it is-
marriages.
It is trying to say that all constitutional institutions are trying to take cognizance of the change.
No, sir,
and various
Mr. Muley, can I just come in for half a second? Mr. Muley, the
Please.
central point that you are trying to make is that this is a law which, if it sort of becomes the law, if it is followed, it is going to protect people from fraud. That is based on the premise that there is systemic fraud which is taking place, which has been detected in marriages or relationships in this country, which is why something like this is required. However, the NIA was tasked by the Supreme Court in 2017 to examine 11 interfaith marriages in Kerala, including Hadiyas, concluded in 2018, and said there was, quote, no evidence to suggest that in any of these cases either the man or the woman was coerced to convert. No monetary inducement or organized plan was found. I can give you many more examples. It just doesn't exist.
But that
This
doesn't mean
entire
that
love jihad as a part of the NCRB data doesn't exist. It's a fake
course.
construct.
Well, as of now, what we can definitely say that in the past it was not captured and has been not tabulated as a data. But now we are moving
In all of these years, we've not tabulated it, sir. It doesn't exist.
Yes, it doesn't mean that it doesn't exist. That's what we are saying. That's what we are
I
saying.
can say that it
doesn't
doesn't.
mean
Okay,
that-
Mihira, please come in.
Yes.
Sir, Mr.
There is a 5th point. As you said, there are 5 parameters that the Supreme Court will look at. You're absolutely right. It will look at the intent. It will look at, whether or not that restriction is reasonable. It looks at one more thing that you did not mention, whether what is being done by that legislation has any reasonable nexus with what it is trying to achieve, right? Whether the impact of that legislation has a reasonable nexus with the intent, right? So there are several reasons here why this law is flawed, and one of the things that you pointed out, you repeatedly mentioned changing demographics. I think that itself points to an unconstitutional purpose and intent of the legislation, because it shows very much that what is guiding this legislation is bigotry, is fear of a Hindu majority nation. You especially said in border areas, changing demographics. I think we are all very clear in our understanding of what this means. All right, that is not a valid purpose. There is no reasonable nexus between what this legislation is saying it is going to do, which is prevent fraud, and what it is actually going to do, because no part of this actually prevents fraud, nor is it necessary, because other laws already exist, right? So on all of these parameters, this legislation does fail. It will fail. It is quite clear. All that it shows is what the government's intent is.
All right, I'm going to leave it over there. I'm completely out of time. It's a debate which comes back and forth in different avatars. We leave it over there. Thank you all very much for being with us. Out of time on Left, Right and Centre. All right.